In the European Union, there are restrictions under the EU Data Protection Directive on sharing personal data outside the EU. The Article 25 of the EU Data Protection Directive says that you can't share personal data to a country that is not deemed approved as having adequate data protection laws in place to provide protection to individuals. The EU-US Safe Harbour Programme is effectively an accord that was put together some years ago between the European Commission and the Federal Trade Commission of the US, whereby to enable businesses in Europe to safely transfer personal data from Europe to the United States. The Safe Harbour Programme basically requires US businesses that want to receive personal data from the EU to sign up to 7 key data privacy principles and to certify to the Federal Trade Commission that they are what's called Safe Harbour compliant. It's interesting to note that the Safe Harbour Programme has still only a few thousand US corporations self-certified, and so there's clearly many businesses in the US that are not using Safe Harbour as a mechanism to safely receive personal data from Europe. It should be remembered that the EU-US Safe Harbour Programme does not apply to businesses in the banking and financial services sector. Most of the EU data protection laws, and indeed the EU Data Protection Directive, say that if you have consent from an individual to transferring personal data outside the EU, then it's safe to do so. However, many of the data protection authorities have given views and opinions that consent is not an appropriate mechanism for transferring personal data in relation to HR or employee data. And the reason for this is that individuals or employees are not able to give consent freely in an employment scenario simply because of the problems of the employer-employee relationship. US multinationals that want to receive personal data from their subsidiaries or affiliates, or indeed distributors in the EU, need to carry out an audit to understand what compliance they need to have in the US and what compliance their subsidiaries and affiliates need to have in the EU. A question that I often get asked by American corporations is, how do I make my American company compliant with EU law? And I usually answer by saying, well, you don't. What you need to do is to make sure your EU affiliates and subsidiaries are themselves compliant with local EU law. So the starting point we normally have is to do an audit of the EU subsidiaries to find out, are they compliant with French law if they have a French operation, or English law if they're in the UK, or the law of Belgium if they're in Belgium. And that means asking, have you notified with the regulator that you process personal data? Because failure to do so is a criminal offence. Do you have in place policies and procedures that deal with the various compliance aspects of local EU laws in relation to data protection, in relation to monitoring of employees in the workplace, in respect of information security, and so on? And once you've done that, then you can move a little bit closer to answering the question, can I get this data into the US from Europe? And if we can tick the boxes and say, yes, you're notified, and we can tick the boxes and say, yes, you've got a privacy policy, and yes, you've got policies and procedures in place, and yes, you've got training for your staff, then we can say, what are the mechanisms we can rely upon for this data to be safely and lawfully transferred? And it's going to be either consent, or it's going to be consent and the use of model clauses, or it's going to be consent and safe harbour, or it's going to be consent and binding corporate rules. And In all and any of those cases, you would then have to, in many of the EU member states, also notify the local regulator that you're transferring personal data outside the EU back to, say, the US parent. So there's actually quite a lot to do to get a US multinational into a position where it can get hold of the data that it would expect to be able to use anyway. The European Commission has a list of countries that it has deemed safe to transfer personal data to, and this is usually after years of analysis of that country's data protection law or laws to see whether they do indeed provide the same level of protection to an individual as our EU laws do. And currently, the countries that are deemed safe to transfer personal data to are Argentina, Canada, Israel, Andorra, the Isle of Man, Jersey, and Guernsey, as well as the Faroe Islands that were recently approved in the last year. There are a lot of companies that we talk to who have used either safe harbor as a mechanism for transferring personal data, or they've used model clauses or model contracts that are approved by the EU to transfer personal data. But of course, that isn't the only thing that you need to do. So for example, in France, simply being safe harbor certified would not enable a French company to transfer personal data to that US safe harbor certified entity until that French company has also notified the French Data Protection Authority. And indeed, that is mimicked in many of the EU member states. So you have to think, have we notified the regulator that we have got in place some adequate protection? You may have to produce that protection. You may have to seek permission for the specific transfers of personal data to that third country. And if the data that you're transferring contains sensitive information like sexual preferences or health records or trade union membership, then the sensitive nature of that means that in many cases it is harder and harder to get permission from the regulator to transfer to that third country.